Okay, so today I'm on my way to Granada. In fact, I'm just arriving in Granada now. What we're going to talk about today is a situation where two brother and sister in this case have inherited from their dad a property in Granada, and now they're in disagreement regarding the sale of the property. The sister wants to keep the property, the brother wants to sell the property. So let me tell you how this came about, and then the solutions that we're going to try and find for this client, and also explain why I'm in Granada today. Okay, so the problem came about is our client came to us 15 years ago. He was an American. He owned a property in El Laifin in Granada, and he came down to Marbella and made a will with us, simply leaving everything to his two children. At the moment of him signing the will, he did mention that his kids, one of them may want to sell and one not. My mistake, at that moment in time, I didn't think of recommending that he gave us as executors the fact to dispose and distribute the estate, in which case then we wouldn't have this problem, because we could enforce the sale if necessary. Hindsight's a good thing. We learn through experience. This is now the third time I've had a problem with children inheriting and then not agreeing on the sale of the property. So now we always offer this possibility, this extra faculty to the executor in case this situation happens. But anyway, we are where we are. So the kids, right at the time of, so when they called us, one of the children lives in Florida, the other one lives in the UK, now lives in the house here in Granada, and the house has been inherited. So at that time, right at the beginning, they were causing difficulties, not wanting to sign the acceptance of inheritance deed. She didn't want to, because she didn't want the property to be sold. But in the end, we managed to get the property, the probate wound up, because I needed to get tax clearance within the 6 months. So in the end, they both accepted to sign the deed, and basically what I did with that is kick the can down the road and leave the problem for a bit later. So now where we are is the property's in the joint names. She's living in the property, and the other brother has now flown over from Florida. This is his first visit over here. He's at the house. They're both at the house at the moment waiting for me, what we're going to try and do today is try and help them resolve the dispute. So what am I going to do to try and find a solution, or help them find a solution? Well, one is I've got two estate agents. They're going to visit the property today while we're there to give an idea of the value of the property. I'm going to be there, so I'm also obviously going to have an idea on the value. When they inherited and we valued it for the probate, we gave it a lofty valuation because there was no inheritance tax to pay, and it hedges future capital gains tax. So that's already been taken care of. But we need to have a sort of an exact amount, and we need to, in all cases, we'll need a value, whether it's for the one to buy the other one out, or whether it's to sell it, or if they can't reach an agreement, at least we have a valuation. The valuation is going to be done for free, because both the agents are doing it on the basis that they may get the job of selling it, even just on the may get the possibility. So anyway, so I'm going in there armed with some information for them. One is if they don't reach an agreement on the sale, and one wants to sell and the other one doesn't, there is a court procedure in Spain called the solución de condominio, which is for these cases, and the one that wants to sell could actually force the issue through the courts, and then if they can't reach agreement, the property will be sold at auction and the money split between them. This is a good case to threaten with, not a very good case to actually implement, because the properties at auction tend to go for a lower than market value, so they both lose out. But obviously it's an instrument that she needs to know does exist, or she can't simply say, I'm not budging in any way. That's one option. The other option obviously is to explore the possibilities of her buying her brother out. And so we're going to have sort of an idea of the value before the end of today, which is going to be useful. So we have the two agents valuing. I'm going to give them an idea as well, and we'll sit there together and go through websites of different agents, and just basically at least agree on a fair market value. what is the fair market value. And then with her buying him out, I don't think she's got the sufficient money to buy him out. We could look at exploring the idea of financing. I don't know enough about their situation at the moment, but we're going to find out today. I can also give them the option of buying him out with what's called a condición suspensiva or resolutoria. In other words, on the title deed, we do a payment over a series of years, and we can actually establish on the title deed that if the payments are not made correctly, the title deed reverts into the two names automatically, and therefore it could be in other words, it could be sort of in effect a purchase from her to her brother, in which both parties are kept completely safe by the deed that would be made. We would have to establish just a small amount of interest, even if it's symbolical, on that delayed payment, because otherwise the tax man would consider it a donation and send them a donation tax bill. We've seen that mistake made before, so obviously we wouldn't make that would be done in that way. So, and obviously, the other option is they can't reach an agreement, then we'd have to put the property on the market. If we had to follow the court procedure one against the other, I've got my own personal problem. Is that I'm not sure that I can handle it, because it may be considered a conflict of interest. I'd have to ask the Law Society whether that would be possible for me to handle it, or I'd have to find a colleague to handle it for the brother that wants to take it forward. If they decide to simply sell the property, we can handle the conveyance for them. If one buys the other out, what I would do is I'd do a title deed, what's called the solución de condominio, which is a special title. Instead of doing a title deed of sale of half the value, we do what's called dissolving the joint ownership. The advantage is that you end up paying 1.2% document tax instead of 7% transfer tax. Basically, you do it that way. Instead of being called the price, it's called compensation. It's a special procedure to dissolve joint ownerships of properties that can't physically be divided up. That's it in a nutshell. I hope you found the video useful in case you end up being in this situation. There are solutions, and anyway, one way or the other, this case has been going on and on and on, and today we've got to find a way forward. Sometimes if everything's really clear, it actually helps, I think, avoid family conflicts. Thank you for watching.